in day-to-day life to all of us. Now, injunction, as you know, is an order of court. We see many cases, numerous cases for injunction in the law courts. Now, injunction is a discretionary remedy. No one has a right, claiming a right. That remedy. Now, in the recent unreported judgment of Kaviratna Nihar versus Mandula Pereira and DFCC Bank, SC, appeal number 89 of 2019, decided on 12 October 23. The injunction, Justice Surasen refers to this injunction. In this injunction is an equitable remedy and is not available as a right. Such injunction will be granted at the discretion of the court. The effect and purpose of such injunction is to preserve the status quo of the subject matter of the action until the final judgment is delivered. Now, when you enter into injunction, one of the most important judgments in Justice Amarasing's judgment is Amarasingh versus Mitsu. Right, Lordship has stated that an injunction. Sometimes it is best to grant an injunction so as to maintain the status quo until the trial is over. At other times, it is best not to impose a restraint upon the defendant, but to leave him free to go ahead. The remedy by interlocutory injunction is so useful that it should not be kept, it must be kept flexible and discretionary. It must not be made subject to strict rule. That is the important injunction. It is so flexible that it is best to grant at the it is best to grant. That is when we see some that is granted, some that is when they refuse, we get it from the court of appeal or high court. And then the Supreme Court and they are set aside. That is the beauty of the injunction. It must be kept safe, flexible. Now, injunction, the procedural law and the substantive law are only two different places. The substantive law is found, as you all know, in Section 54(1) of the Judiciary Act. The procedural law is found in Section 662, 664, and 666 of the Civil Procedure Code. And almost all the judgments deal with these two aspects. Example, now one of the most important judgments, as all of us know, is Justice Sosa's judgment in Philistine Bandaranaike State Corporation, 1981 USA law, page 287, where Lordship has set out the law related to procedural law and substantive law, which is also cited quite beautifully by Justice Savayavardhana in the recent judgment of Palikavardhana Arachike Shiroma Dilruch Jayawardhana versus Shaldan Rodrigo, SC Appeal 39 of 2017, decided on 20th May 2022. Then we have also got a good judgment of Justice Padman Surasena, her Hema Fernando versus Madhuri Rodrigo, SC Appeal 53 of 2021, decided on 16 November 2021. Logic analyzed this case with judgments, repeated judgment beautifully. So those cases give us always some knowledge of the judgment that are decided from Philistine's case up to date. Same principle, but at times it is better put from time to time. Now, both procedural law and substantive law are important. If we fail to follow the procedural law, we will not get the substantive relief. On the other hand, if we ask for the substantive relief, if you follow the procedural law and don't ask the substantive relief in terms of the law, then you will not get it. So both procedural and substantive law are equally important. Now, if I deal with the procedural law, injunction can be applied with the plaintiff. Very clear from section 54(1). Where the plaintiff, on the plaintiff appears, on the plaintiff, court is granted, and no question, which all of us will take. Pending an action also you can ask for injunction. That is in terms of section 662. There you have to file a petition. Action is filed by okay, but pending that you file a plain petition supported by affidavit. And affidavit is necessary in any event to support the injunction, whether it is filed with the plain, after plain, or petition. Now, therefore, a question of the import of validity of affidavit is necessary. Without an affidavit, no injunction can be supported or given. Now, validity of an affidavit, you all of us know, is governed by section 181 of the Civil Procedure Code. So it says, you have to mention these from your own personal knowledge. The only exception being when you get an interlocutory order, when you want interlocutory order, support for interlocutory order, you can mention from not your personal knowledge, but you can say your reasonable belief can be set out. But when you set out the reasonable belief, you must give the reasons whereby you have made that belief. So you are normally you must say, I know personally. But in the injunction, you can ask for your knowledge is not personal, but you will come to know. But then you must give reasonable grounds why you say that you have to know. And in that context, the reason, if you examine the cases reported in judgment in Karunadasa versus Yusuf, 51 in NLR, David and Company versus Albert Silva, 51 in NLR, page 326. David versus Albert Silva, 31 in NLR, 316. There the Supreme Court has said, affidavit where you say, I have belief that he is going to do is not there. And then to settle the reason why we will have to do. That's when filing action, for example, if you hear, after we file action, if you have to negotiate and sell the property, you have no personal knowledge. But if you are going and negotiate with someone or some firm who is dealing in real estate, if you can get an affidavit from that person that he is actually come and consult you, or you want to negotiate for the sale, such a thing will be useful. Otherwise, you will not be able to substantiate your belief. In that you can't, then evidence will be valid, not valid, and the action will be. Then other important aspect of affidavit is found in the section 183A of the Civil Procedure Code. Now it says, if you are filing an affidavit on behalf of a company or an institution, there you can't really say, I so and so. There section says, you must read that it is from your personal knowledge, and that plea must be there. But if from personal knowledge, you must set out that you have personal knowledge. If you don't set out you have personal knowledge, such an affidavit will not be valid in terms of 183A of the Civil Procedure Code. Now that section has been analyzed by Justice Sarat Silva in Damayanti Abhyavadana versus Hemalata Abhyavadana. 1993 Mannesella, page 272 and page 281, which has been cited by Justice Vimala Chandra in Umma Amina versus Zawahid, 2004, 2 is in page 1. So in the Umma case, the person, they had filed an application by the revision in the Court of Appeal. And the affidavit was not filed by that particular person by a power of attorney holder. When application filed by the power of attorney holder, In terms of like I heard other than he have to say, I am doing it with my personal knowledge. And that can be mentioned. It was not mentioned in the affidavit, and his lordship held that affidavit not valid and the affidavit was dismissed. Therefore, whenever we file an affidavit by a third party on your behalf or on behalf of a company, you must mention in the affidavit you are doing it with the personal knowledge. Please do so, otherwise affidavit will not be valid. Then when you, the substantive law, now as when you see the procedure, before going to interim injunction, you also know interim injunction cannot be issued without notice and hearing of the other party. It is some rule, then injunction can issue injunction. But we know there is something called enjoining order, which we can obtain without hearing the other party, pending the interim injunction application. That is governed by section 664 to the Symposium code, in terms of which, if the court is satisfied that the object of granting an interim injunction would be defeated by delay, court is entitled to give an enjoining order, restraining the defendant from the same acts or nuisance for a period of 14 days. And that can be extended only upon, can be only extended until the interim injunction is only upon sufficient good grounds be recorded by court. An enjoining order that is given by court, ex parte, can be suspended in terms of section 664(3). It says the court on its own motion or on the application can be suspended. But the question might arise, that's because whether since the other party got the enjoining order ex parte, are you not entitled to set aside ex parte? Now, that aspect has been considered by the Supreme Court in Finnegan versus Galadar Hotels Limited, 1989, 2SLR 272. But that was considered that case dealt with the civil procedure code before this section was introduced. So there was no section as regards setting aside. But the other court held, since it is ex parte, there you have misdemeanor court will be entirely by using inherent power package. But then the court also held, since once you have issued the injunction, enjoining order, other part, that person who gets some rights under that, it is best that that person be heard. I don't see any new cases on that matter, but probably applying the same rationale, and as that is most of the they want notice to be given. But also court can act it on its own motion, there is no reason, perhaps to invite the court to set out these things, and the court gets essentially the power given under that section. Now, that also, that we have also the provision in the section 666, which says the enjoining order or interim injunction can be discharged during the set aside on an application be made.
Sir, excuse me, sir, sorry for interrupting. Is there a possibility that the organizers can give whatever you are saying to us?
Yes.
It's very important for us, sir.
Thank you.
You're giving valuable output for us. So if they can.
All what you all know, actually, that is the law. I don't know.
But it's like being a new student under you, sir.
Okay, thank you.
Thank you so much. It's very valuable for us, sir.
Thank you.
Thank you for my.
Thank you.
Thank you, sir.
Thank you. Then we have also section 664 of the Civil Procedure Code. In terms of the enjoining order, interim injunction granted can be discharged when it was set aside on application. Therefore, the question will arise, if a person tries to vacate an enjoining order and the court has not done, or when a party comes to court, shows objection against the interim injunction, equal the court holds and issues an interim injunction. But in those circumstances, nevertheless, whether you can find a fresh application under 664 to vacate that enjoining order interim injunction. Although you have had a chance, court has made an order, still this provision makes provision for you to come to court. And that has been considered by the by Justice D'Souza in Ajit versus Ceylon Paper Sets Limited, 2003 SSR page 6. Where his lordship has taken the view where the injunction is issued after full inquiry, after the opposite party has filed objection. That party cannot then once again avail himself under section 66 to have the application. Settled by the same issue. That we have to clear into court. And if all these inter parties, then although this section says so, the lordship does say this is as well, you will not be able to have a second by the decision. Now coming to the substantive law, as you all know, is governed by a very small section. It's one section, section 54 of the Litigation Act. There's one section which has created that amount of case law in our legal district. Now under section 54(1) provides for three situations for injunction. As you all know, 54(1)(a) provides where the plaintiff demands and is entitled to, as seen from the plaintiff, to restrain the defendant from committing or continue to commit an act or nuisance which in violation of your rights you are entitled to prevent the person. So 54(1)(a) contemplates an action for a permanent injunction, where you seek to restrain that person from committing an act or nuisance which violates your rights. That's a permanent injunction. And permanent injunction, as you know, can only be sought at the beginning of the action by way of plaintiff. We have seen some cases in the court. Some lawyers have filed the action, when the action they file petition asking permanent injunction issue under that injunction issue. Which is wrong, which cannot be done. Permanent injunction can only be asked for by the appeal. And therefore, permanent injunction is a remedy that can be sought only at the beginning of the case by your plaintiff. And under the permanent injunction, in terms of 54(1)(a) says, the court is satisfied, the violation is going to take place of the rights, then you can restrain that person by issuing injunction from committing that. Now, the second instance is an injunction we see pending the action. That is governed by section 54(1)(b) of the Litigation Act. It says pending, it says that during the pendency of the action, if the defendant is doing or committing or procuring or suffering threatens to do something, an act or nuisance in respect of the subject plaintiff, right? In respect of subject matter of the action. He must do something or continue to do or procure to do something which violates the plaintiff rights in the subject matter of the action. Now, that is not enough simply, it says, which will tender to render the judgment ineffectual. Where someone is trying to do something with respect to the subject matter over which the plaintiff has right, and if that is done, the judgment that you will seek finally, or you have sought finally, will be rendered ineffectual. That is the situation where you seek to prevent a defendant from doing something which will render the judgment ineffectual. If you get the judgment out, it will be of no use. Therefore, you say you will maintain the status quo. Therefore, that action, that injunction, you ask where the defendant is done, file action. So, you have to file an action for ejectment. You simply file action for recovery of property and ejectment. And then you find the defendant finally is trying to demolish the building. So, if you demolish the building, then you will not be able to get that property back. Therefore, pending that action, you are entitled to file an action, say, he is trying to do something of the subject matter which I have the right. And if it is not stopped, that will be rendered ineffective. Therefore, restraint they will be intent. And that section is the section which we very often use in almost all courts, daily use. The third action is to restrain a defendant from alienating or transferring his own property with intention to defraud the plaintiff. There you are preventing the defendant, third situation, from alienating or disposing his own property with malicious intention where he wants to defraud money. For example, I file action for recovery of some money, and the defendant's only property is an estate which he has, and he is trying to alienate that property so that my recovery will not be possible, then I am entitled to file an action. Although I am seeking a recovery, but I am entitled to prevent him from alienating his own property, where he is trying to do that to defraud my rights. Those are the three instances of the which. Now, what exactly section 54(1), that is injunction from plaintiff against defendant. The same privilege or right is given to a defendant by 54 subsection 2. But in the same action, defendant also, as you know, obtain an injunction against the plaintiff, but he must satisfy that he can only file an application if he has a claim in reconvention. If he has no claim in reconvention, he has no right to claim an interim injunction against the plaintiff. Now, section very clearly says, 52 says, provided the interim injunction be obtained by a defendant against the plaintiff, that he must have a claim in reconvention with affirmative judgment. You must seek an affirmative judgment against the plaintiff, and if that affirmative judgment is going to be, fruits will be denied or will be rendered negative, then you are entitled to file an application against the plaintiff. Therefore, you see, law provides for a injunction by the plaintiff against the defendant and defendant against the plaintiff. And defendant can only claim if they have a claim in injunction. Now, that has been considered very well by Justice Soka De Silva, who became the Chief Justice, in Mallika De Silva versus Gamini De Silva, 1999, one is Sedlar, page 85. Now, in that case, it's a divorce case where the plaintiff filed action against the wife, and the wife was living in the matrimonial home belonging to the husband. Husband, now, defendant filed an answer. Wife filed an answer and claimed that the plaintiff action is dismissed. The land committed, which said, I am not committed. Now, pending the action, the husband tried to dispose of the matrimonial home. Then wife came to court, filed an application saying he is trying to dispose the matrimonial rights that will affect my rights, therefore restraining from disposing of the property. The court held it with the wife and granted the injunction, which went out, and court pointed out that she is not entitled over much. It's morally justified, she is not entitled to claim the injunction because she had not made a claim in reconvention. Since she had only had action in this. Therefore, the court held where you have not made a claim in reconvention against that defendant, you are not entitled to claim the interim injunction. And therefore, the interim injunction was set aside. You have to have a claim and allowed affirmative judgment. Then, proceeding from that, it says defendant can claim against the plaintiff in a recent judgment. Justice Surasena has said, in view of those provisions, a defendant cannot claim an injunction against another defendant. He can only claim against the plaintiff. And that was held by his lordship in the judgment Karagita Nihal versus Bandula Petra, which I referred to earlier, 89 of 2019, decided on 12 October 2023, where his lordship pointed out an injunction from the plaintiff, defendant to plaintiff, and defendant cannot file an injunction against another defendant. That has not been cited in such beautiful way in other judgments. Then the other fundamental principle of injunction is a disciplinary remedy, right? Which injunction which is seen for pending an action. Therefore, interim injunction can't be asked without a main relief being obtained. Only main relief, then only interim injunction. Now that Justice Soka Silva pointed out beautifully that in Mallika Silva's case, that divorce case, where lordship said, interim injunction is a relief that cannot be granted solely or independently without any final or substantial relief. That is so fundamental. Therefore, in some cases, we have seen injunction being filed without the main relief. However, issue we will want without the main relief. This only supports the main relief. Therefore, without the main relief, injunction cannot be filed. Then, in other instances, another good judgment is Hajo versus Vikramasinghe, 1999, 1 SLR 82, where the Supreme Court considered the concept of injunction in relation to pain. They said injunction can only be obtained within the four corners of the prayer and nothing more happens. Now, in the Hajo's case, a plaintiff filed an action to declare a karate resolution filed by the bank void and the transfer of the property under that to be void to citizen. And the plaintiff made the bank and the new purchaser parties. While the case was in progress, the person who purchased started to demolish the building. Then what happened? The plaintiff went to court by a petition and said, my action will lose all the merits if the property is demolished. And he got an order restraining the defendant from demolishing the property. The went up in appeal, and His Lordship Justice Amar Singh considered this and held injunction is limited to the prayer. You can't control the other activities of the parties. And it's a beautiful judgment where Lordship said that. He said that injunction relief is designed to prevent the frustration of the court's order if the relief prayed for in the plaintiff eventually granted. And it is not designed to prevent other activities of the parties. And the injunction was refused. Therefore, whenever you ask for injunction, be careful to say injunction is in the four corners. But the parties do subsequent to cover in that action if we had perhaps asked. That initially, the example if we said that he not intended to demolish the building, we are saying we are challenging, then we could have got that. But we didn't do that. We only challenged the resolution. And therefore the court said your rights are limited to resolution. Whatever the subject matter is not the subject of that. So be careful in draft the papers in that way. Then, now we know this, as I pointed out, section 554(1) remains refers to permanent injunction. 54(1)(b) refers to injunction pending the action. 54(c) refers to an injunction preventing the defendant from continuing or property. This question has been, if you examine the recent judgment of Justice Surasena in SCAP 53 of 2020, decided on the 16th of November 2021. It's a quite an interesting judgment which discusses the minor details which are necessary under certain things this section to establish. Now, Section 54(1)(b), where the defendant is to be prevented, where he is trying to interfere with the subject matter of the action over which I have the rights, tending to render the judgment ineffectual. His Lordship has said in that judgment there are two requirements necessary. His Lordship said that plaintiff must satisfy two requirements. Firstly, an occurrence of an act or nuisance in violation of plaintiff rights must be subject to that. There must be an act, nuisance, which affects minor rights of the subject of action. Secondly, the occurrence of that act or nuisance would render the judgment ineffectual. Therefore, even if there is something to be done by the defendant, in respect to the subject matter, which no doubt will affect our right, but if it doesn't affect the final relief, then injunction will not be able to be obtained. Must establish not only doing something, that will affect my right, my enjoyment of the fine and will be lost. That was used in the ineffectual. Now that in that case is another Justice Ivamana Sundara's judgment in Kalavindana K. Don Chandravati versus Carmen Angelique Silva, SCFP 179 of 2015, decided on 19 September 2017, is quite interesting. Now, in that case, the plaintiffs claim that they are the owners of the property. On the basis, and said the defendant had no title, that the first defendant was the wife of one of the brothers of the plaintiffs. The plaintiff filed action after the brother died. The brother's wife was the first defendant. Second defendant, the brother's child. Is there willing to challenge a marriage between the dead brother and the first defendant and produce an affidavit to say by a person who has signed for that as a witness, I have never signed. And they challenge the validity of the marriage of the brother and try to prevent the defendants from alienating the property in the applicant action they sought to recover. So they was arguing that they cannot challenge the death of the brother, the marriage of the brother after his death. In any event, it was argued, even if it is so, I can transfer the property because you are saying the property is yours. If I transfer the property and if you according to you, I don't have title, no title will pass to any other person. Therefore, if no title, defendants don't have title and no title passes to a third party, still you can get judgment, which is effectual. Therefore, in Lordship, Justice Deji, Justice Eva held that in that case, or then the defendant had, if you contend that defendant had no title, transfer of the defendant to a third party will not affect the plaintiff's title, and therefore there is no irreparable harm, and there is the judgment that is sought by the plaintiff will not be rendered nullified, and the injunction of it. Then all as well as the application for including injunction under subject of 1, 2, or 3, or there are certain principles which govern. As you all know, that those principles have been discussed in numerous chapters, which is very often referred to as 3 sequential tests. All know it. And that all that sequential tests have been examined in detail in many cases from time to time. Starting from Phyllis Bandaranayake's case, 81 USLR to 85, which also, and there's a good examination of that by Justice from my in the known case Subramani versus Shanti, 1984, 1 SLR, page 48. Similarly, there's a beautiful examination of Justice Victor Pereira in Siravati Bandara versus Mini Kirtiratna, 1982, 1 SLR, page 85. Justice Saras Silva has a beautiful examination of those principles in Ghulam Hussain versus Cohen, 1995, USLR 370, and a beautiful description by Justice Dr. Amarasinghe in the famous case of Amarasekar versus Vissiu and Company 1990, 1 SLR 22, and most recently by Justice Chandra Ekanayaka in Karyavasam versus Sujata Janaki. The most recent judgment reported in 2030, 1 SLR 176, and in the other unreported judgment I cited by Justice Surasena, that the same principles are discussed. Now, pick the substance of those 3 sequential tests. According to Justice Souza, basic. First one is a prima facie case, a prima facie or prima facie winnable case. Number 2, balance of convenience, and number 3, equitable consent. All of us know them. All of us know. Now, if you say a prima facie case, What does it mean in law? Does it mean that you must prove to the hilt that you have a right and you will win that case? No. Courts have said no. You must establish on a balance of probability that the chances are that you will win the case. As against it's a mere action which has no merits. You must establish prima facie available case. And that has been examined in many cases. Now, prima facie, certain courts have pointed out, you have to have a serious mental defect. Very often they have said you must establish a prima facie case. So, whatever happens, you have to have a serious case or a prima facie case, a winnable case, to show that your rights are going to be affected and it will be actually granted. Now, those have been examined, and all those cases that I have referred to, and this case also is Phoenix Ventures Limited versus Superior Areka Private Limited, 2012, Bar Law Journal, 179. Now, all those cases, they were the same principle. Now, what is prima facie and how should one establish that? Has been discussed. I think if you examine Karyavasam versus Sujatatan Jadagi case, that gives the entire principle very, very beautifully. Now, he says, in Karyavasam's case, Justice Ekar Nayaka says, the plaintiff must show that the legal right of his is being infringed, and that he will probably succeed in establishing his right. There is an infringement of right, and I will succeed in establishing that in court. A prima facie case does not mean a case which is proved to be guilty, but a case which can be said to be established if evidence which is laid in support of the same were believed and accepted. The evidence that we say is evidence we believe and acceptance. So there must be bona fide evidence to show the rights are to be accepted. And if it is believed and accepted, then it will establish that your rights are. So that's a prima facie you need not prove guilty about that. Yes, H. cited lovely judgments from India and Supreme Court, which, as you know, if you read that, it's a very clear picture of what is prima facie proof. Then Justice Amarsekar says, we did also another principle that is seen in all those cases. In judging a person's prima facie case, court doesn't look only to the plaintiff's pleading. That is judged by examining the plaintiff's case with as against the defendant's case. Defendant's documents, pleadings, submissions, and therefore, as a whole, it must be taken. And then, therefore, when we think that this is enough, when we file papers, this is enough to establish a right, it is not sufficient because competent lawyers will appear for the defendant. They will also set the law properly in all those documents. And therefore, documents which we don't get, they will establish and say, because of these documents or because of the deep legal principle, the plaintiff case cannot be established in law. So therefore, the court says that the district judge shall have been satisfied, should be satisfied that the plaintiff has a prima facie case and a reasonable prospect of success even in the light of the defense's case, in the pleadings, objections, additions of the defendant. Therefore, as a whole, therefore, when we file an action, we must always think, what will that person say? Very differently to your who goes to study it. But have that in mind when you seek an application. Then, if the court says, fundamentally, if you can't establish a prima facie case, you will be injunction issue and other sequential test sheet of the consider. Now, prima facie case, it says in this case, what is a right? How do you establish your right? Now, you know, a cause of action is defined in section 5 of the Civil Procedure Code, which refers to the plaintiff. There must be a right of the plaintiff, some damage that is suffered by the plaintiff, some claim that the plaintiff came. So, cause of action is with respect to the plaintiff. right, I think, has been examined by Justice Sharlananda beautifully well in the Ceylon Mercantile Union versus Insurance Corporation of Sri Lanka. 80 ml page did not match. Then one of the final judgments where the Supreme Court has considered what is the cause of action. How do you present? When do you say your rights are affected? Now, Lordship points out for a cause of action, first thing there will be a defendant, plaintiff, and a defendant. And your plaintiff must specifically show by the act of the defendant your rights have been violated. So, unless you establish that, there is no cause of action. And for that purpose, you must establish that defendant is doing something. And if you can't establish that all the other cause of action against the person whom you are attacking will not arise. Now, one of the final judgments to examine what is the cause of action, how does it arise, what are the requirements, Lordship has considered very well. One of the final judgments in my opinion. Now, and that is also very seen from the very wordings in the section called your rights should be affected. You can't ask for any other right. Now, as we have that, where your rights are to be affected, there is a judgment where the courts, a person filed an action, against the neighbor on the basis that he is trying to establish a hotel and the fumes that will generate from the hotels and the other thing will cause a nuisance to you, and therefore you have a right to restrain him. Are you remember the case? So in the injunction case, we are both examine this first to the admitted no, I can't. Was it in 19? The key one thing is the where the court held. You can't merely say that because you are trying to prevent by the injunction the conduct of my neighbor of his own property. And everyone is entitled to use his property. But that use cannot cause a nuisance to the neighbor. So, court pointed out in those cases you must have high standard of proof that what he is going to do is injurious to your health or will commit some nuisance. That's a reported judgment. Sorry, I will give that judgment in a moment. I can't remember where okay, that's it. That is it. You know the you check on that, please. I'm sorry, I don't have at the moment, but I made a note of that. Then, for the prima facie then prima facie, once a prima facie proof is done, then you go to the second element Justice Sosa pointed out, balance of convenience. Therefore, you consider if the injunction is granted in favor of the plaintiff, and if the action is finally defeated, how will the defendant suffer? And if the defendant is injunction refused, and finally the plaintiff succeeds, how will the plaintiff suffer? So those comparatively, you compare with the injunction. Granting of refusal and the interim injunction will granting and refusal as to how that will affect both parties. And in that case, there one has to consider whether it is compensable or it is irreparable. In other words, can you maintain your fundamental belief that we are so? If it is not, so you balance the consequences, both parties suffer. If it is granted, if it is not granted, if we are finally successful, we are not successful. And that is examined in all the cases. dealing with, one case is Subramanian versus Shardi's case. And he says that irreparable injury to be an injury that cannot be adequately compensated in damages. And where damages are proper remedy, or is actionable wrong, then injunction will not be available. And that has been decided, Jinadas versus Will Singer, 31 and page 33. Now, another case of interest is judgment, that's Ranaraja judgment in Hyderabad Industries Limited versus Idak Trading Limited, 1995, 2SLR, page 304. Now, however, courts have tried to revisit the question whether merely that the person can be compensated will it mean that injunction will be reduced. And I think that's it. Amal Singha, in Mitsui case, has sounded that one must consider whether it is in fact sufficient or not. And his lordship says, cites the English judgment and has stated, if you go to Amal Singha's judgment, it's very clear on that. He said the standard question in relation to grant of injunction is, are damages an adequate remedy? Perhaps in the light of the authority research years, we leave it. Is it just in all circumstances that a plaintiff should be confined to his remedy in damages? The courts have repeatedly recognized there can be claims under contracts in which, as yet, it is unjust to confine a plaintiff to his right to damages only. So far, the question of adequacy of damages has been discussed on the footing that if judgment was recoverable, the sum awarded would be paid. Then the logic question is, but whenever the adequacy of damages falls to be considered in this class of cases, that raises further question: are the defendants good for the money? Although it is recoverable, if the defendants are good for the money, if it can be enforced by the cannot be, it's not good, then he says that the fact merely that damages is claimable should not prevent the grant of an injunction. And he also says, but whenever the adequacy of damages falls to be considered in class of cases, there arises further question: are the defendants good for the money? Also, if they are abroad, will their government's exchange control permits the payment? In other words, will the judgment be satisfied? Therefore, merely the fact that it is a compensatable damage or injury will not be sufficient. As Lordship points out, if, for example, if you vanish that bill, no compensatable is recoverable, but if the person has no value, he can't afford to pay, then what happens? You won't get money, you won't get money. So he has said that can be revisited quite correctly. Then we have equitable consideration. Even if you have some case, prima facie case, balance of the case, then the logic will point out equitable consideration. Now that is also, if not, Justice Souza deals with that beautifully. When his lordship said, the third test is the equitable principle, that is such as dealings and conduct of the parties, how the parties have dealt before the injunction. That is discussed in detail in Ceylon Hotels Corporation with Ayatunga, 74 in 443. Then Justice Souza says, feeling very simple. Lastly, the injunction is an equitable relief granted in the discretion of court, and the conduct and dealings of parties are relevant. Has the applicant come into court with clean hands? Then also said, has his conduct been such as to constitute acquiescence in the violation of infringement of rights, as the Court of Appeal has said, and those other conduct will be. Sorry, that case where he said where you are trying to stop a person from having a running a hotel in the next door is Aru Sabrami versus Kavidadi, 1983, USLR page 493. judgment of logic as GPS the silver, and logic examined law in detail. Where one of the few authorities, American is where you have to stop the injunction by you have to stop the neighbor from benefiting or doing what he wants. He can do so long as it doesn't interfere with your life. Then, therefore, equivalent, suppose if I have agreed that you can do something, you can't really come and complain that it has been in your offer letter. How to block that? And you must come with clean hands. Now, this is a discretion remedy our courts have in terms of litigation authorities based on certain requirements as to how the discussion should be invoked. Then with that they say, court has to exercise the discussion. And if you exercise the discussion, court must be told all what is relevant for the case. Otherwise, the court will not be able to exercise the discussion. And therefore, they have developed this doctrine that a party who comes to court seeking an interim injunction enters into a contract with the court to act in prima facie, to disclose all the material which are relevant to the case. Therefore, now the law is settled that you must act with prima facie. All what is relevant to the application, even if it is against you, must be disclosed. If you don't disclose of what I said, you have suppressed the material facts, therefore we will not hear you. Even if you have a good case, you will go. Now that case, as you all know, that has been discussed in detail by Justice Victor Pereira in Apuhami versus Hediar. Alfonso Apuhami versus, Justice Patita. In Alfonso Apuhami versus Hediar. 77 and then 131. I think one of the finest cases where this principle has been laid. The lordship said, plaintiff applying ex parte comes, as has been allowed said, under a contract with the court, that he will state the whole case fully and fairly to court. That is fundamental enough. And then that principle has been discussed with a step further by the divisional bench in the case Fonseca versus Jagat Jayasuriya, Fonseca's case, 2011, USL, page 372, where the lordship have said, we know you support the application ex parte. And then the interim order may not be granted. But notice of injunction will be granted. Then the other person is entitled to come to court and show notice also should not have been issued because he has suppressed material facts. Then one might think, although he had got the notice, at the time the interim injunction inquiry is sent and all is made, you become inter parties. Therefore, suppression of material facts is not relevant. But that is before court. But the court says no. Even if you have taken one step and thereby the court thereby losing the discussion had issued notice, that is enough to set aside all. And that was discussed by Lordship Justice BASL in this case, Fonseca's case, 2011. And he says, he points out that by suppression of facts, you have got notice. And therefore, whatever you say now, court will not consider and applicable discussion. And that is also then the case in the judgment in Walker Sons versus Vijay Sena, 1997, 293 is also an important case where their lordship consider what is misrepresentation. What is misrepresentation? Now, there, Justice Ismail cites with approval Justice Atukola in Hotel Galaxy case, that in 1987, page 5 and 6, he says, a misstatement of true facts, there must be a misstatement of true facts by the plaintiff, which will put an entirely different complexion on the case as presented by him when the injunction was supplied by ex parte, would amount to a suppression of material fact warranted in the decision. That if there was something which you have taken from court, which you have put a different complexion in the minds of the judge who issued the injunction or notice, then that is a suppression of situation. And then the lordship also says, at page 301, is it? Party who have misrepresented cannot thereafter teach that misrepresentation was due to an inadvertence or misfortune, or that the application was applicable not aware of the importance of certain facts. And then Fonseca's judgment also is important, where they say you need not personally know that particular thing, a fact you have to report. If it is something which you could have with your reasonable exertion of facts, which is reasonable effort you could have known, then that must be told. The fact you could not know personally doesn't matter. And also also Justice points out another very important matter. The material facts are those which are material for the judge to know. In dealing with application has been, and he says, materiality is to be decided by court and not by the assessment of the applicant or his legal advisors. The matter for the court. Then we have some of the injunction purpose is set out beautifully in some states. Purpose is to maintain the status quo, and that is reflected in almost all the cases. Where status quo are related to maintain the court is in kind of injunction. Then I find a few matters very quickly. One other question that arises always for us is whether you can get by your interim injunction the relief which you can get in the final relief. You always say no, if you grant interim relief, final relief is granted, therefore you cannot be granted. And that point has been dealt with by Justice Vimalachandra in Shell Gas Limited versus Samya Nampa Limited 2005 to 3 SLR 840. My lordship considered this in this judgment and said, if the defendant has no defense at all, then the court is entitled to grant by interim injunction a relief which may in fact amount to the final relief. You have no defense at all. Now there the facts is clear. They are a Shell company, they are a defendant company, right to sell their gas, and they also put a vessel to store the thing. And they say after termination, I do not object for us to recover the property. Terminated, but he refused. Then they went to court and said, this is, they have admitted this, and on the basis of official court granted the injunction, restrained them from removing, and they removed, which is in fact a final relief. But court said, in those circumstances, there are circumstances where you have no defense at all, it would be unjust not to grant the injunction. That is done by Justice Vimalachandra, which has been cited with approval by Justice Tilakavadana. But subsequently, in Rasasiri Kasivanaji's case, 2010, one is page 227. Then one other matter, there are few matters. We always say we try to get an injunction to restrain a person from entering the land on the basis he has no right. No right. And as you all know, that we dealt with the whole case, House versus Janegama, 48 and a final to say a person is wrong from occupation cannot be checked. Then as again the new development has come in the law. So if you can't take a person who is in wrongful occupation, then we should be able to prevent him from taking benefits from his wrongful doing. That's why we recognize in many cases which I have cited. All these cases they exist. But with one exception I found, he reported in Halilibelu versus Asoka. One Sri Lanka lawyer, one not two. Where the Sri has said, if it is a trespass is new, then you must be able to prevent by an injunction and restore the status prior to the trespass. There the trespass was about 10 years old. So he granted the interim injunction, otherwise we will be protecting a person who has no rights as he is a person. Then here also no this injunction has been obtained to matrimonial actions. And that is seen in Dias versus Kodituwa 4, 1999 ASL page 354. Where they say there no reason why injunction should not be in a civil action, and Justice Dilakwa's held that injunction is available in criminal actions. Then one other matter is they have been also injunction has been extended to defamation cases. That you claim damages from defendant, but you are also entitled to prevent the defendant from continuing to publish defamatory material. And that has been discussed in unreported judgment by Justice Chandra in Unapatana Beach Resort versus 1 Everday, CALA 121 of 2003, dated 1st February 2005. The Lordship said if the act complained by the plaintiff is in a continuing nature and continues to be repeated, such situation generally injunction will be issued and cite curve on injunction. In the case of trespass of continuing nature, how will the court will grant an injunction, which has also been considered by Lordship Justice Souza in Felix and Matlana's case, at case did not fall. Justice Souza says in a defamation case, in an injunction, it must be first, it must be defamatory, then there must be no defense, the other side, such as defense of truth or public benefit, and 3, nothing has occurred to deprive the plaintiff of his right. That has been dealt by the society. Then one more last matter I would like to say. This question has also arisen if there is an arbitration clause, can you get it? Section 5 arbitration clause says if the arbitration clause is in a contract and the defendant relies on that arbitration clause, the court can do it up to grant. The question has arisen in cases where in terms of arbitration clause you do arbitration. But pending arbitration, then you have the threat of payment being made or something being removed. So how do you get? That matter was dealt with by the case of BASL's Textile Industry Limited versus Hydro Industry Limited. Court of Appeal 51 of 97 decided on the 20th of April 1990. Where Lordship Justice Edrisuni said, as far as arbitration clause is concerned, then no doubt that the Arbitration Act provides for settlement of disputed arbitration where the agreement is so. It has been contended that the petitioner has already referred the matter to arbitration, and also the Arbitration Act provides for implement. However, in my considered view, until such time a final order resolves in arbitration or interim by arbitrator parties, where you have made reference to arbitration, till the arbitration starts functioning, the court said, again, you can go and obtain an injunction. And that has also been seen, they have done the same thing, and examining LB Trade, LB Trade Lanka Private Limited versus Innova Tires, 2011, Wow Social Law Journal 130. The same concept has been applied. Then, one more. In the recent case, the very recent judgment, they have also gone to court under Article 143 of the Constitution. Now, that Article 143 provides that the Court of Appeal has the power to grant injunction to prevent an irreparable injury which might ensue before a party can make an application for such injunction in a court of law. Now, there, the parties were referring to arbitration. Pending arbitration tribunal is constituted, they go to the district court, they came to the Court of Appeal in Alusan Limited versus Ranman Holidays Resorts, CA injunction 505 of 2024. There the court issued an injunction, Court of Appeal under Article 143 of the Constitution, injunction to be valid till the arbitration is constituted. And for the first time, the Court of Appeal recognized an arbitration body to be equivalent to a court under that section, articles usually. Then we get mandatory injunctions in law. Although we see injunction restraint, but mandatory injunctions, although our law says restraining, that's what the court in Venus was a period. 2002 in 128 and with this material says the word restraint from doing something can improve the way the words, the meaning to compare. He said therefore mandatory injunction in all law can be granted under this. So those are the few things that I. Oh, also the Ganikam 40 agenda page 73. So these are the few nuts and bolts which have to be highlighted in the law. I hope I have expressed myself and thankful. Thank you all for your attention. Thank you and God bless you.
Thank you, sir, for that insightful and engaging discussion on nuts and bolts of law of injunctions. I am sure our participants learned a lot from sir's session.
Yes.
To appreciate Mr. Ikram Mohammed's contribution to make this session a success, I cordially invite Mr. Rajiv Amar Surya, Chairman of BASL Webinars and the Symposium Committee, to present the token of appreciation on behalf of the committee.
Ladies and gentlemen, we are moving towards the second session of the day. This session will be conducted by our resource person who has actively contributed to the amendment of several acts and ordinances, held various significant positions within the legal community, and she is a respected resource person who regularly participates in seminars and conferences. Please welcome Mrs. Shiranti Kanwardhan, Senior Instructing Attendant, to deliver the second lecture.
Thank you, everybody. It's my pleasure today to address this symposium. I know Rajiv has done so much during the past so many years, bring these webinars and seminars, and to ensure that we all learn something. So I'm very happy to be here, and I can thank Rajiv and the seminar committee, especially these youngsters who are doing a wonderful job. Because I must tell you, when I started supporting, this is not lecture to speech, when I started supporting Rajiv, so many people asked, why are you being so much senior supporting the junior? I said, it is our duty to see that juniors are made seniors. So therefore, congratulations everybody for the lovely lectures, seminars, webinars. In fact, I must tell you, I learned a lot from your lecture. You know, I made my notes, which will be very useful to my day-to-day practice. Thank you, everybody. Now, first and foremost, I must tell you, we go to the first one. This, the amendments which came into being in 2022, then it was revisited in 2024. There are a lot of issues which still remains unclear. The reason for that unclearness is, number one, because we have not understood the law properly. Number two, the administrative side is giving us enough problems. If I ask any of these practicing lawyers, how many of you all have issues? Everyone will have an issue to say. Now, first of all, the amendments were introduced. The amendments were introduced by Amendment Act in 13 of 2022 and 6 of 2022, the Notarial Ordinance has conferred a significant challenge to all of us. Then, you can go down the side where I do that will be easier for me. Right? Now, why was the reason for the amendments? Because the notice ordinance came into being in 1907. Thereafter, there were amendments from time to time, but these amendments were needed, number one, because there were so many frauds taking place. Massive frauds where millions worth of properties were being subject to fraudulent deeds. Number two, there were so many complaints made against lawyers. I am sorry to say, a very senior lawyer, more than 50 years, was punished by a rule because of a mistake in a deed. Therefore, we thought it is best to get all the amendments for the benefit of the lawyers and the customers. So I will just discuss the bullet points. Now we will go one by one. To go on for that, now number one is not so important. I know most of you all are not apprentices, but we thought we should introduce that when you start writing deeds, you must have the exposure. I want to tell you, I'm going back to 1970s, where when I was an apprentice, I never took it serious. But some of my juniors who are here will say, I'm one of the strictest teachers when they become my apprentices. Because you tend to make mistakes when you don't know what it is. I will give you the first mistake that I made as a notary. I'm talking in 1976. When I joined the People's Bank, I had to write a deed. And the deed was for the People's Bank to buy a property. You know what I have done? I wrote the deed, but I stamped it. When I stamped it, those immediate telephons like this, we have to get a trunk call. So I had no way of asking anyone. I was in the northwestern Florida. I wrote the deed. Then I was asked by my senior, Mr. S.M.D. Jayasundar, who's a man from God, to come. And by that time, I was pregnant with my first child. He looked at me and said, Shinalji, you are very lucky. I said, why? He said, you have done a big mistake. I will tell you how to overcome that. He told me, when you have wrongly stamped a deed, which is need not be stamped, under the stamp ordinance at that time, we have the right to pay 2% and get a refund. So that was my first mistake, because I never took my apprenticeship serious. Anyway, along the way, I learned that we have to study. We have to look at the books. Then only we can do this. Now we will go on. So therefore I think it is very important that all the lawyers, all the notaries who want to practice as a notary should get that certificate. Then, date of annual renewal of the notarial license. Now, that's a very important point for all of us to remember. Now, if you sometimes when you go and call for a duplicate from the libraries, you never get the duplicate. I'm sorry to say, even very senior lawyers' duplicates are not being found sometimes. Why is that? The reason is stamp. The stamps I'm not casting any aspirations on any lawyers, but I regret to say most of the deeds have not been properly stamped. You know, there was one case, a very big company in Sri Lanka. I'm sharing these experiences they want to know, where the company used to give money on teas, you know, anti-factories are money on teas. And for those, they used to do mortgage bonds. But to see, they went and sued one client for 10 million. But the other side said there's no mortgage bond. Because instead of the mortgage bond, the notary has written last will is the duplicate, stamp is not paid, mortgage bond not executed. So that company when they went and did a search, almost all the mortgage bonds were large fields or powers affected. So therefore, that is what we thought. When we introduced this new law, we thought we must protect the lawyer and the client both. The annual renewal of the notarial license, 1st of April, under section 28 of the amending Act 31 of 2022, and an affidavit, and not only that, with the notarial license, you must give an affidavit to say that you have given your duplicates. Because that is very important. And what is the repercussions? What is the repercussion if you don't do it? The repercussion is for every deed that you attest, there's a 50,000 fine. When I was a notary, my first notary in Notarial, it was only 50 rupees. It is not now. So that is also very important date in our notarial practice that every year our notarial license must be renewed. Okay? The other things that were down the line again I will discuss. The other thing that was discussed is fixing of photographs. Actually, we brought this to for every deal, but there were so many issues. One person said, if the politicians buy a deed, buy a land, if the photograph is there, it will be circulated to everyone. So because of that, now in 2025, we did the amendment to say a fixing of photographs in the last one, which is very important. Then transfer and gift and deed of exchange compulsory, and impression of the thumb impression of course is compulsory. All the deeds. Why did we introduce the impression of thumb impression? Why? Because half the time the practicing lawyers here will say, every time a person will say, I never signed it. That's a general, they say, blank papers, blank, we didn't sign, it is not our signature. Some people even in arbitration have taken in and said, even after big term settlements are entered, they were not present. But because of that, we said thumb impression, you can call evidence of the thumb impression. So it will not be easy for people to say, we never signed the deed. The notary must be responsible for the true nature of the transaction. If not, a fine of imposed not exceeding 500,000. Now, this is a very, very important introduction which came in. Because there are so many unscrupulous money where instead of mortgage, what they used to do, they used to get a clear transfer. And because the Uttaramate was not there at that time, now of course we know we have to get the stamp commissioner's approval. People used to write properties worth millions, they used to get it transferred, and they used to own it. Thereafter, come on get the program pushed out. To prevent that bad practice only, we say that the notary must be responsible for the true nature of the transaction. Then comes the identity card. Earlier also there was a regulation by the Inland Revenue where it was made mandatory to the NIC number. But in the present law, we have to get the national identity card, passport, or the driving license. I want to tell you, we just go one step further, which I always do. When the client comes, take the identity card, passport, or the driving license. I get them to write on the copy, say, this is my NIC, and I get them to put their signature and the date of the signing of the deed, because it will go one step further where you are protected. Okay? I get your, not only remember, you must get the identity cards of the witnesses also. Then comes stamp payment is the responsibility of the notary. Now, this is a very important thing. I will share again that experience. As you all are aware, how do we pay stamp fees? There are three ways actually. We pay stamp fees for the central government for mortgages and leases. When for transfers, gifts, we pay the stamp due to the provincial council. And for provincial council, what must you all do? You all must go to the numbered banks which have been given. So what happened was, when you go to the bank, what do you get? Have you seen the notice who are here will know? No, it's a time thing. On a time. A very serious thing happened in the western province, where several notaries have employed a clerk, one common clerk, who will go and pay the stamp fees and come. Then, under the new law, we are put originally in the recorder, then we put a copy in the protocol, and as it is now, of course, we have annexed the stamp one also to the original when we came for registration. See, this girl has paid out 600 million stamp fees of several lawyers. Right? And I know as a government servant who was only practicing notarial practice, this girl had to sell and then what is the penalty? If the deed is not properly stamped, what is the penalty? 300%. You know, this poor lawyer, this government servant, had to sell her own house to pay the deficit stamp fees. Because in fact there was a question now, sometimes people call me or can, but is this some other currency? Unlike those days, now they don't file action. They insist you pay the stamp fees. So because of that, we have introduced this new procedure. As a notary, I think my practical advice is the stamp fees, if it's a high value deed, however much you are lazy go to the bank, you should well pay it. Otherwise, you tend to lose because if they bring this kind of fraudulent receipt. Then, go to the next one. The notice name, that's another important thing. The notice name with the deed shall must be signed on the face of the deed and if working as a legal officer, the place of employment. Now, this is very important. You all must all know, especially if you are a legal officer in a bank or a finance company, you tend to change your notarial license from 1 to, when you are in Pune, you have 1 to 400. Then you come to Colombo, where you start with number 1. But sometimes, when you can look for now, say, I am a notarial license in Gurudam because I first started there practicing for the people's bench. Then I have attested at 400 fees. All of a sudden, some people call and say, Madam, we need the name. Then I say no. Because when I sign in Kurunnagar, I give my duplicates to Kurunnagar. But when I practice in Colombo, I give my deeds to Colombo. So therefore, it's very important. But people don't know those days we didn't have this practice of putting anything on the top. We only put the deed number, we put our name, and then that's the end of it. But it is not so. Now, on the face of the deed, you have to put all the details, including your notarial number. And if I am the officer in People's Bank, I must say legal office of the Northwestern Province. So actually, this has made it very easy for the customers, for the clients to get the details. Then comes the monthly list. Of course, this is not for our benefit. The monthly list is for the benefit of the government. It was introduced for internal revenue purposes. Because from 2014, they have been pushing us to do this, which we never agreed. But now, by law, it has become mandatory. The monthly list include NIC number for all executors, divisional secretary division, where the land is situated, local authority in which the land is situated, and the stamp you pay for which institution, central government or provincial council. It's a very recent amendment that came in, but it is mandatory. We should all include this. I think it's for our benefit, because as lawyers we also take all precautionary method, but it's for the benefit of the government to collect their taxes. Then come, then amendment of attestation, I will discuss it further later on. Then comes, it is mandatory to number the pages, deeds and instruments. Now that is another. Now earlier, there were no numbered pages in a deed, but presently it is mandatory that we number all the pages. Then search. Now this is another one. Those public people who write deeds, they will say, you can download this and use a CD, search spreadsheet. Now you cannot do a deed with search spreadsheet. You have to do a search. It is mandatory. Not only that, you have to get the last step, certified extract, apply from the land registry, and then stick to your protocol and keep. So there is no mercy if something goes wrong. You have to face it. Search is mandatory under the new provisions. Then comes the power of attorney to include the description of the schedule in case of condominium parcel and the other elements should also be included. Not even in the power of attorney for condominiums, even in the power of attorney for other lands, the schedule must be properly given. You know, earlier we did that on a general power of attorney. People used to go to town. People used to always write deeds or powers of attorneys. And sometimes when the people come to Sri Lanka, they find their lands have been alienated. But it is not so. The power of attorney must have the schedule. In the case of a last will, it is mandatory to mention in the attestation and testation was in good, sound mind, memory and understanding. The monthly list, that is another important thing. Do not remember, I had an interesting case where I lost the case in the commercial high court where the company had to pay 6 million in the deficit of, when you mortgages property, if you get more than the valuation on the amount due, that money has to be refunded. So the commercial high court Justice Manika currently gave an order. Please make the balance 6 million payable to the client. Meanwhile, there was we filed a leave to appeal and to see this lady die. This Mrs. Sirisena died. After Mrs. Sirisena died, there was a claim made by another professional saying she is a niece of Mrs. Sirisena and she wanted this money. In fact, she sent me certified copies from the Valadikya district court saying there was a last will and they are a beneficiary. I got a little suspicious because I knew this Mrs. so-called Sirisena didn't have heirs. Her husband died, she died. So what I did was, I went. I got this, now the last will is out, when the last will is proved, I went to the Valadikya district court, applied for the certified copy of the entire case record, with the entire case record, the last will also came. Then I went to see this lawyer is a person practicing in Thailand. Now this is the girl who has filed the proxy. This is the girl's husband. Is the lawyer who is practicing in Thailand. I applied for a copy of the monthly list. What has happened? The monthly list for that month is nil list. Right? The monthly list. So many people were able to do so many underhand things by using this last, because I can remember long time back, even in the people's bank, it was a joke. Sometimes if you miss to number one deed, sometimes your deeds are numbered by your technical hands, they say, oh no, last week in the land, because no one is bothered. So to prevent that, fraudulent acts, only we introduce this. Then, now I will go, now in December, Act number 31 of 2022, amendment was done. Section 31 amendments, the duties of notary. Now, as you are all aware, if I ask all of you all, even I will say, I had to read because I was instrumentally changing these laws in the starting to custom and the deed. Otherwise, for a notary, what is the most important section in the notary's ordinance is section 31. The rules are given beautifully, which we have to follow. So I am now discussing with you all one by one. Signature is not to be taken in blank papers or incomplete documents. Now, we cannot take any blank papers, signatures on blank papers, but I am telling you, the good old days there those printed forms. You go, you pay 50 rupees and get those deed of gifts, deed of transfer. You used to get it signed, later on you used to get your clerk to do it. But it is not so now. So even those days the law was there, but now we cannot get any blank papers signed. Then further amendments, signatures not to be taken on blank papers. Rule 3 of the notice ordinance was amended by section 31 of Rule 3, which introduced the thumb impression. So thumb impression came in to be from 2022. Then I have put the whole section of the thumb impression and we have shared the note with you all. So I have nothing to worry, you all can go through that. Go to the next one. These we type on parchment stroke blue sheet. Now all of a sudden I realized when you look at this, there are these being done even in A4 size papers. There are these. To stop that, we introduce parchment actually. Parchment is yellowish. But parchment is very expensive. So because of that we say blue paper. But I am telling you all that it must be of a durable nature. Therefore, at least I of course as a practice get my original done in a parchment. However much expensive it is, if you can get the yellow parchment, that will be very important to you. Then these to be typed on your individual papers, undivided papers. If it is not undivided, what must you do? If it's divided at the end of each page, you will have to ensure that the parties and the notary signs. Then, number every page, there is a notary signature in each paper. Cause every executant, hold of common attorney or directors of a corporate body or authorized officers to sign and affix their left or right thumb or any finger to impression. Now, this is also very important when you are doing powers of attorneys. I have seen some people, when the power of attorney is given from Banda in America, who must sign the deed? If Banda is abroad, it must be America who signs it. But in the face of the deed, whose name must you mention? You must mention name of Banda. You cannot mention the name of America. And then whose photograph must be affixed? Not Banda's photograph. It must be Manica's photograph. Because Manica is the one who signed it. So these are simple things that must be noted by you. Then the payment of stamp I have discussed already. Go to the next one. They noted to pay the stamp say then comes rule 9. Notary should know either one of the executors of the deed, instrument or the two witnesses, or the identity of the executor are established by such note by inspection of the national identity. Actually, we made it easy for you. I will tell you a nice thing happened to a lawyer in the Kennedy in a finance company. This young girl has attested about 10 deeds. For all 10 deeds, she has got her clerk and the typist to sign their witnesses. Then you see, all these deeds were fraudulent. Then one night I get called, and I know she's a very honorable girl. She, at about 11 o'clock in the night, she says, Madam, I have no question. Because the CIA came, I have a question. මේ ඔප්පුවට සාධිකාරයෝ මම දාලා තියෙනවා සාධිකාරයෝ මම ගන්නවා සාධිකාරයෝ මේ මනුස්සයව හඳුන්වනවා කියලා. නමුත් සාධිකාරයෝ වශයෙන් අපි දන්නේ මැඩම් කිව්වෙන් අපි අස්සාරි කරා. And you see the executor is a fraudulent person. It's a fraudulent identity card. So what is the position? Now this is still the High Court has still not started the case. She's still in contact with me, but she is in internal fear. So why must we take that extra risk when the law provides us to do everything correct? So therefore, I think we must, this notarial practices must be followed very strictly, and you must never get your office people, call the driver, call Manika, call one and sign. You must ensure that two very respected. Now, if I do a mortgage not to a company or a bank, you know what I do? I insist the manager or the second officer comes before me and signs it. Because then sometimes they will say, no, madam, please don't do that. Please don't do that. You must ensure when you are accepting a deed that you are doing the correct thing as a notary and the witnesses, the executor, all of us must be there. Don't because you know when you are threatened, when the CID threatens you, the answers you give, they will only try to safeguard you. And you must remember, for a notary, if you are challenged for signing a fraudulent deed, the witness box is a very lonely place. So don't do it. Then comes the rule of we are both executing issue tomorrow. That time I have said that. Good rule 10. Where both person executing the deed and attesting witnesses are not, that is also done. Rule 40. Which with provisions of ascertaining full names of the executor and the witness, the executors, power of attorney holders, directors of a body corporate. Now, how do you know if it's a corporate deed? What we all do? If a deed is to be signed by a body corporate, what are the things you must call for? You must call for the certificate of the incorporation. You must call for the names of the directors. Then you must call for the company seal, but there are some companies, they say no need of the seal. You must always have a resolution. And sometime, and now of course remember, unlike those days where we had to pay for a trunk call, if you have a credit card, you can do online search. Am I not correct? You can register companies, you can ascertain. I have got not only I ascertain, I get a printed copy and put it in my deed. So remember, if it's a corporate body, these are the documents you must call. Certificate incorporation, the resolution, and the most current list of directors. And whose photographs must be annexed? The directors. But sometimes, some companies also authorize their CEO, general manager, managing director, one person sign. Then whose photograph must come? That person's photograph. Don't get into all the photographs. If a power of attorney holder is doing it, whose photograph must come? The power of attorney holder here, not the principal, because you are saying this fellow signed before. So you have to be very, very careful. Then you know, left of computation, then signatures, full names of holder. Then sections of the preventions or fraudulent amended. And this is very important. Now, all of them know every time. Sometimes people are asking whether the mortgage has to be signed by both parties. Is that so? No, a mortgage bond can be signed only by the mortgagor, not by the mortgagee. So now, at one time, under 2022 amendment, it was mandated that the directors also sign of the people's bank of Ceylon. So people used to curse us. They used to say, But it is our fingers up. අපේ ඇඟිලි ගියවිලා දැන් මේවට මාස්සක් කරලා. So because of that, now as I told you earlier, deed of transfer, deed of gift, deed of exchange, those are the things we have to sign. Now executors conveyors, administrators conveyors, beneficiaries need not sign, only the executor or the administrator. Now also remember, although I have not included in the note, the executor or the administrator sign the deed. Tell me in tests, how do you do? So now I act as a consultant to a company where there are deeds being written every day by lawyers. And recommending title, also you have to be very careful. Because there are one or two points, though which I have not discussed, I would like to share with you. Debt Recovery Special Provisions Act. What does it say? Debt Recovery Special Provisions Act number 2 of 1990. Categorically says under section 13 of the Debt Recovery Special Provisions Act that if you write a deed, right? If you write a deed, but there's what Debt Recovery Special Provisions Act under case index, the case has been filed. What will happen? If you buy that property, what will happen? What will happen? That deed is null and void. That deed is null and void. But as note please, there's a lacuna in law. You must get the law, people to obey me. But what will happen to man today? Our deed, we are reading. What does it become? It becomes null and void. You know, I will tell you an interesting story like that. There are two finance companies at the fight, where one finance company has filed a DDR case. Other finance company went and seized that land. They got a transfer deed also done physically. But the first finance company brought in the DDR registered. So what was declared? That is null and void. So remember, everything not go by only the rules. We have to look at yours. The Land Acquisition Act. Tell me, in the Land Acquisition Act, Section 7, Section 38, Section 4, are they registered? Are they registered in the land registry? If anyone can say it's registered, I will give that person prize. No. Now you all know the famous case of Heather Mundy's case that you would have done for administrative law. Now that case, I was personally involved in that case. That what happened in that case, Heather Mundy is a Sri Lankan worker. She had dual citizenship. Her husband was the head of credit cards in Dubai. They had a lot of money. They came to Sri Lanka, they want to come and settle down. He's the one who established the credit card in HSBC. He came and bought a property. They got a beautiful property in down south. Not down south, in the whole Bangladesh. To see. Now they were going on, they built a beautiful house, they built a lovely swimming pool, 3.5 acres of land. One day, I can see this Hedamani and her husband. They came to, I didn't know even they were such important people. They came running to my office. I said, what has happened? See, Shirangi, our deed was written by no other person other than Mr. Alex Jayasekar. He was my guru. He would have been the guru of most of the senior lawyers. And to see the Road Development Authority came and served a notice to say our house is to be demolished. This palatial house is happened within these 20 years. So what happened? Did we have a way of saving the house? No. So we went to courts. When we went to courts, before Justice Mark Fernando, she said nothing to him. She went even to the world, she went internationally also. She gave so many, she did not have research. But we never got the case. But one good thing happened. All the people there, they got the correct valuation. Now again, they have built a lovely house in Kokorovita. They happen to be my good friends. They are very happy that house has gone. But now, luckily, I was able to understand, look here, it is not Alex Isaac's fault. Whose fault is that? The statutory lacuna in our country, when there is something like that, you don't know. And I will tell you another case I have faced within two banks, two big banks, only 2 weeks back. There was a property. The owner is in Canada. Owner sent a power of attorney and sold his property for 340 million. Right? When he sold it, as usual, they say, oh, we have get the last extract. These people have got the extracts only 5 days before. They extracted nothing. So, one bank, this person sold his land, and one very big commercial bank settled the other bank. By giving 320 million. So now you know as usual what they all do. Does anyone send the deeds for registration? No. We wait for 4-5 days. It's a very bad practice because we have in the law book a protection for us which we are not doing. You know what happened? To see, there has been a freezing order registered in the land registry. Land registry. Now, one bank is not giving the money because they have settled their loan. Other bank, the 2 lawyers, but I have to tell you, those 2 lawyers have taken all precautions to protect themselves 5 days before they have got an extract. But how could have this girl been saved? Tell me away, if anyone of you can tell me and tell them. What must you do if it's a high value deed? What must you do? Priority notice. Now most of these people think these are all fashioned. Why should we bother? But when you give a priority notice, when you sign, the priority notice date back to that of the early one. So remember, these are the issues which we have to face practically whatever is stated. Then number 2, do you know the Fragmentation Board Act? What happens in the Fragmentation Board Act? In the Fragmentation Board Act, register legal land registry can the folios? No. Then what must you do? If the property is more than 9 acres and 2 rooms, to whom must you go? You must go to the Fragmentation Board and get your property. Again, we face issues. When there are election, no fragmentation. So we have to sit and wait. But it's better you explain to your client the difficulty rather than explaining to the client your issues. Then also the other fragmentation, powers of attorneys. Then again, deed of gifts, when it is the law 2017, Act number 5 of 2017, what does it say? What does it say? That you can give a deed of gift, even if it is irrevocable. Now remember, even if it is irrevocable, for gross ingratitude, if that offense happened within a period of 3 years. Right? Now there was another, I will tell you another interesting case, where one fellow came and mortgaged the company, the son came and mortgaged the finance company. The case number also I remember 647 in Kalveda. He came and filed a case if he mortgaged the land. Thereafter the father files gross ingratitude case. Now the case is being heard in the district court. Can the company realize the asset? So what is the best advice if you are doing on a deed of gift? Within 10 years, what do I recommend to you all? What must you all do? You all must get Don and Donnie to sign. If both Don and Donnie sign, you are okay. Or else, you must call for the day search. You must call for the day search. Sometimes some people say day search is not available. But you can't say that. And then, always, in a case, if it's a larger land, you will have to get a letter from the Urban Development Authority to say this land is not to be occupied for public purpose. They did that. They did that. So you must remember there are the notice ordinance plus the powers of attorneys plus the last will plus the registration of documents order as given. But also you must remember there have been enough issues with the land registries because they have their own laws. Actually, there must be uniformity. Now, I think we are working with Rashid, where we want to get a uniform regulations passed, where we all have the same issue. Because sometimes they say monthly sticker, certified copy, they only need it. Sometimes you have to give a copy of certified copy of the duplicate from the land registry. You cannot give a certified because within how many days do we have to sign the deeds? We have to take the deeds to the land registry. 30 days, it is within your jurisdiction, 60 days. Now, yesterday, earlier was it necessary to register a deed other than for priority? No, but now, what does it say in the new act? In the registration of documents or in the notice on them? We have to register the deed. 30 days, and if it's a power of attorney, 30 days local, 90 days power of attorney also has to be mandated registered. So because of that, you all have to follow these rules, and I think we will have to work towards the bar association and work with them, where immediately we get a mandatory set of rules where the land registers which will follow, because otherwise we will not have these issues. Thank you very much. If you have any specific questions, I think I have 10 minutes more. Yes, I am prepared to answer. Thank you. Question, please, I have understood it. Don't call me and ask. I have not put my head on. That's it. The prior of attorney, because in the transition provisions, they say power of attorney was executed before the powers of attorney's ordinance. The new act will be valid for further 2 years. That is given in the new act for further 2 years. And also remember, though it says 5 years, now this is there where international banking and all is concerned. Because we have to keep on, there are most of the international banks, act on promise of attorney for them, that is Hong Kong and Shanghai banks, Canadian bank, Charlie bank. For those they will say, for these specific purposes are over, if you put them, you can only a general power of attorney can be only for 5 years. If it's a special power of attorney, you have the right to put a clause, say until the termination of this contract, sooner determination, the power of attorney will be continued to be valid. And also remember, now every time when you act on power of attorney, you have to get a
Hello?
Ladies and gentlemen, our next session we have our esteemed guest, Mr. Sadio Lewis, President Council, to present on Sri Lanka's Big Anti-Corruption Act. Mr. Sadio Lewis is the former President of Bar Association of Sri Lanka. He is also the Chairman of the Office on Missing Persons and member of the Human Rights Commission of Sri Lanka. Mr. Lewis holds a master's degree in international business law from the University of London and a bachelor's degree in law from the Open University of Sri Lanka. It is my privilege to invite Mr. Sadio Lewis, President's Council, to present his lecture on Sri Lanka's new Anti-Corruption Act. Over to you, sir.
Yes, so thank you for inviting me to speak at Symposium, and it's good to see the Symposium being divided. And Sadri, and he was secretary of the Bar Association, and it's also good to see this crowd. Normally, I thought the last session you were at everyone goes out, but it's good to see everyone present. So my task is on the Anti-Corruption Act of 2023. So the importance of this is there are some new offences, new powers which are exercised by the Primary Commission, and there are new act also covers the private sector. It covers the private sector, so we must be here aware of the provisions, and not only for those who are in the not only for those in Colombo, normally we identify primary cases, corruption cases with the high courts in Colombo. But I think it is important for us to be aware of the provisions of this new law. So I'm not too sure whether the back you can see this. The CFO, the new Anti-Corruption Act transforms the institution of the Primary Commission, the new Primary Commission, which is appointed under this new act, is transformed. Right? So, if you know that in 19, if you look at the history of how primary cases were developed, up to 1994, you had the Primary Commissioner's Department, and the cases were sent to the Attorney General's Department for prosecution. Then, I think something very important. People who are involved in the primary investigations also here. So probably they will be in a better position to speak to you about the act. But nevertheless, I think so. This new commission is, I think, the most powerful commission among all the commissions in Sri Lanka, because the commission, you know that public that if you take the Attorney General's Department, the officers of the department are appointed by the Public Service Commission. The funds for the various commissions are given by through the consolidated fund, but there are certain controls. Now, when the Primary Commission is concerned, the new the commission established under the new Anti-Corruption Act has the power to regulate. It gets funds from the consolidated fund, but it also has the power to establish its own fund, and expenses of the commission can be defrayed from its own fund. So, the new Primary Commission of Singapore has operational independence, as against many other commissions which don't have total operational independence. So, the new law replaces the Primary Act, which was introduced in 1954. It also replaces the 1994 Act, which established the Primary Commission originally, and the Declaration of Assets and Liabilities Act. 75. And these are all consolidated into this brand new law. The law also enhances the mandate of the Bribery Commission. Now, if earlier the Bribery Commission was only in respect of reacting to offences, the new Bribery Commission has an enhanced prevention mandate. Right? The actions say about beyond reactive enforcement to proactive corruption prevention and education. So on one hand, you see, if you look at the news today, the Bribery Commission is always in the news. You find people arrested, produced, and they very often rightly so for acts of corruption and or bribery. But there is another mandate which the Commission has, that is to educate and prevent. And for that purpose, it can also interact with civil society, NGOs, civil society, communities in respect of anti-corruption drive. Now, one of the most important changes, if you look at the enhanced prevention mandate, the CMO is now empowered to monitor anti-corruption policy implementation, review laws and procedures to identify corruption risks and promote public awareness. So, as much as prosecution, prevention is also stressed upon. Now, the Bribery Commission not only investigates, prosecutes, but it can also make recommendations to the government about reviewing anti-corruption laws. It can also make recommendations to institutions on how to streamline its processes, its procedures to prevent corruption. So, there are many of you who are attached to various institutions. Your institutions also, the Bribery Commission has a mandate to make recommendations to your institutions how to change your procedures to ensure to combat corruption. Now, one of the important changes is the centralized asset declaration. The centralized asset declaration system. So eventually, I'm sure that the officers will be able to enlighten, officers of the Bribery Commission who are present today will be able to enlighten us. Eventually, there will be a centralized asset declaration, a central electronic system for asset and liability declaration. Now, those of you who are in the government sector, you know that every annually you have to submit your assets declaration. Earlier, for the non-submission of your assets declaration, you will fine of 1,000 rupees. Fine of 1,000 rupees. But now that has changed and enhanced punishment. But, now public officials, including newly covered categories like the president, deputy officer, diplomat, private staff of MPs, must periodically declare assets inside and outside Sri Lanka via this system. CMO is the central authority for receiving and managing these declarations, modernizing the whole database regime. So eventually, there should be a system where you have to submit your declaration of assets and liabilities, and the CFO is supposed to be able to monitor those assets declarations. So, in time, so where public officials are concerned, and here if you say public officials, it's vastly expanded. It even includes companies where the government of Sri Lanka or a public corporation has over 25% of shares. Those institutions also come within this definition, right? Both this definition and definition of corruption. So, if you are in a company where the state, where the government of Sri Lanka owns 25%, then you get caught up. There is a question I think it is open for consideration whether now. When you say 25% of the shares are owned by the government of Sri Lanka, what if there is a company where the government of Sri Lanka has 50% shares? That company has 25% shares of another company. Now, does that second company get caught up in the definition? There is a question. There is a question whether, so we say government of Sri Lanka owns 50% of shares in company X. Company X has 25% shares in company Y. Does the company, why they get caught in the anti-corruption framework? Then there is a doubt. There is a doubt. But this is certainly far more than earlier. There are more the anti-corruption regime as well as the filing of assets, declaration of assets. There is a wider coverage for this. So perhaps during a short question and answer time, perhaps I do not know how much this system has really developed, but eventually it would mean that those of you who come with this definition, you will have to launch your assets declaration, and the commission will be in a position to monitor the declaration. So, especially when it's in electronic form, I assume that it is easier then to do the calculations to see whether a person has acquired assets over 1 year, and if he cannot account for those assets. And I happen to see the new declaration of assets and liabilities that seems much more comprehensive than the earlier declaration. But I'm saying this because I see there are members of the officers of the commission also. I think one problem we have with all these electronic systems is that they are not user-friendly. So if you take, for instance, any of you familiar with filing your income tax returns on the RAMs, it is a very complicated system. It takes a long time to even upload some documents. So one thing which perhaps the commission should be aware is that whatever they do, if you want this to be successful, it must be also, for the person who is using it, it must be user friendly. Otherwise, you will find if it's too complicated, then it might get stopped. Right. So that is where the assets declarations are concerned. Then comes new offences. This is one area which I'm conscious that you have to analyze. To remove the next slide. So, coming detail to the new offences, then there is a asset forfeiture can go down. Whistleblower and witness protection, these are some of the main features. I will come back to some of these slides. Lead agency cooperation, bribery in the private sector. Now, earlier, in the private sector, bribery was not covered. So, if you are a manager of a finance company, or you're a bank manager of a private bank, if you take a bribe from a customer to speed up a loan, you don't get caught. You did not get caught up under the old Bribery Act. The CFO of the old days will not be able to catch it. But under the new regime, bribery in the private sector is covered. Bribery in the private sector is covered. Soliciting acceptance offering bribes in the private sector is now an offense. So this is a huge change because if you look at it internationally, anti-corruption measures involve the private sector. If you do any legal work for any multinational company, many multinational companies today require even lawyers to sign a document on their anti-corruption policy. Right? Even lawyers, you have to sign on and say that you must affirm that you will not be getting involved in any corruption, in any matter involving corruption. Right? So that because internationally, that has been the trend. We don't know changes in the United States will remain there. But so now bribery in the private sector is an offense. So although we have not heard so much yet of raids or traps relating to the private sector, now there is an opening. So also then look at it from the point of view of those of you who are practitioners. If a client comes to you and says a bank manager is asking for a bribe, it is open to you to advise your client that bank manager can be reported to the Primary Commission. Because offering, accepting, soliciting, right, even in the private sector, are now punishable offenses. So that is a very important change in the law, right? Then companies can also be held liable for acts of agents. The corporate liability companies, corporations are encouraged to have internal compliance and ethics programs. Private of public, foreign public officials. Now, cross-border bribery is not prosecuted. So, foreign governments and international organizations were offering, soliciting, accepting bribes by on behalf of foreign agents or on behalf of, say, foreign public officials can be an offense. So, you will say you are a Sri Lankan company. You offer a bribe to a foreign agent for some project, either in that country or maybe if they are investing something in Sri Lanka. That would be an offense, right? So we say there is something in Dubai or we say in Malaysia. If you offer bribes to a foreign official, you get caught up in this. So part of this is because in order to signify Sri Lanka, there is a anti-corruption convention, and this is part of Sri Lanka's obligations under the anti-corruption convention. Right. Next, trading influence. So if you use improper influence, to obtain a benefit or a service, either you use or you offer, you solicit improper influencers to obtain a service. That also would get caught up in this. So look at something like school admission, right? I don't know if there will be some ideas to people also you can look at, but if you take school admissions, improper influencing a principal of a school, not necessarily giving the principal of school a bribe, but if you use improper influence to deviate from the marking scheme, you could get caught up within that. Right? So that coupled with the fact that even private organizations can get caught up. Private organizations, it is said, to achieve a commercial purpose or contracts, those are all private organizations can get caught up. So using influence to obtain benefits and services are also made offenses. Then comes another important area, sports-related corruption. Section 108, match fixing and bribery in sports. And there is a regime of mandatory reporting by sports officials. By the way, assets and liabilities, the members of sports institutions under the national sports law also have to file assets declarations. Right. Then, the next one, conflict of interest violations. Now, this is something very new in Sri Lanka. As a public official, you are required to, there is a conflict of interest. And it says if you, a relative or an associate, the person concerned, a relative or an associate. So what is an associate? Associate may be a friend of yours, maybe your staff member, maybe your next door neighbor, all that could get caught up with this term associate. If you have a conflict of interest, you must declare that. So the Commission is expected to promulgate rules to declare conflict of interest. So if you have an interest in a particular matter, you are required to disclose that interest. But if you do not disclose that interest and you proceed to take a decision on a matter, you will be held liable under Section 107 of the Act. Now, in other countries, for instance, members of parliament, in the United Kingdom, for example, members of parliament, there is a conflict of interest register. The independent commissioners have a conflict of interest register. Ideally, the judiciary should have a conflict of interest register, so that you register your interests So if there is some conflict, you must be clear. Before taking a decision, you must be clear. I have this conflict. Right? So section 107 makes it an offense for conflict of interest related offenses. So again, a new area, earlier, where we sometimes know that a decision maker may have conflict of interest. He might, if he discloses and he recuses, he says, I cannot participate in this event. There are sometimes the decision makers take part in decision making, knowing quite well that there is a conflict of interest. Right? We know that that was all along morally wrong, ethically wrong. But now it is an offense. Right? And you're bound to declare violence. Right? The next slide, gratification. The new law specifically includes social behaviors also as gratification, but I must say this. Earlier also there was case law. There was case law where senior sectors also, by case law, they had also been considered as crimes. But now the law covers sexual exploitation is covered in bribery and corruption. Now, there are other, of course, the next slide is. Ancillary offenses, concealing, corruption, obstructing investigations, retaliation, so on. Again, now this is something which I want, especially those who are practicing, will be interested. Now, we know that the penalties are prescribed in the Act. There are prosecutions which are under the Commission, but importantly, the Commission mandate has a power of alternatives to prosecutions. So, two of relating to private sector bribery and sports related bribery and corruption, there is a possibility of prosecution. So, if your client is a suspect, either private sector or a sports body, you seek a different prosecution. What is a different prosecution? If the Commission of Justice there is set out in the national interests, so on and so forth, the Commission can decide not to take the prosecution. Secondly, that would does certain things, right? May give certain undertakings, which they might be required to make a statement, which is approved by the Commission. Perhaps apologizing for what has been done, right? Promising non-recurrence, and but on various conditions, the Commission can decide to defer prosecution for a period, and during that period, if the prosecution, if the suspect complies, then the prosecution they will not be prosecuted. That is one aspect. The second aspect is withdrawing prosecutions. In all these cases, the Commission has discretion to withdraw prosecutions again with the permission of the court. If the suspect, if the Commission will have to satisfy that it is something which withdrawal is very bad, but on certain conditions set out in the law, they can withdraw the prosecution. But again, the suspect they will have to make some sort of admission, ensure non-recurrence. In certain cases, even undertaking that they will permanently not hold public office. On those conditions, the Commission can, with the permission of court, withdraw the prosecution. So, for those of you who are in criminal defense, keep that in mind that the only way out for our client is not to go to trial in each and every case. I say this in private cases, in other cases. especially since in my position I do prepare the papers. We see certain cases which can be concluded in the magistrate's court, cases which can be concluded in the high court, the lesser sentence, sometimes the suspended sentence. Lawyers tend to advise their client to go to trial, but sometimes the client insists that they want to go to trial. And how does it end? It ends up with a conviction and a higher sentence. So in certain cases, if you feel your client's case, you have to evaluate, check the strength of your client's case. If your client has a weak case, these are options to explore in the commission, to make representations to the commission to consider either in case of private sector bribery or sports-related bribery and deferred prosecution, or in case other cases also. I don't know what the policy of the commission is when you withdraw cases, or the law permits them to do that. But in certain cases, where maybe if your client is a victim of certain circumstances, if his involvement is marginal, then this is a way to explore, right? Rather than trying to go to trial, challenge everything, and 4-5 years down the line, your client ends up with a long jail, right? So I encourage those presently avoid criminal defense to look at the law, look at these options of deferred prosecution, withdrawals, which is possible, which it is possible for the under the new Anti-Corruption Act. Right. So I avoided this because of this. Then there is the witness protection enhancements. So confidentiality and support is provided aligned with the international best practices. Right. Now, investigation procedures. Now, the new law provides for joint investigations. And now, earlier, sphere of investigation was separate. CID or the criminal investigations were separate. And sometimes you can come across cases, one case is filed by the bribery commission, the other case is filed by the attorney general. One case, one is a witness, in the other case, the other is named as a accused. Right? But now there is provision for joint investigations. Right? The commission can sign a memorandum with any other investigating authority. And there can be a joint investigation. Recently, I came across a case where I was in court, Justice Koda, in this particular manner, suggested to the Attorney General's Department that the Bribery Commission initiate a joint investigation. So now you can have the CID, the Bribery Commission, all getting involved in a particular investigation. And we don't know how those modalities will work, under which direction it will be, those are things to be sorted out. And as lawyers, we might be able to also find grounds for objection, etc. But the law provides for joint investigations. So, let's go there. Improve investigative procedures. Multidisciplinary teams, special rules authorized, surveillance, forensic audits, asset freezing. So now the commission itself, just like the Money Laundering Act, property could be frozen, assets can be frozen, the commission also can freeze property and then move the High Court to extend the freezing orders. Then there is one particular slide. Can you just go back to some of the previous slides? Okay. Asset forfeiture. So all this time we are used to a person being convicted and assets being forfeited by the state. Now, under section 115, the Director General of the Bribery Commission can apply to the High Court for asset forfeiture, even where there is no conviction, right? So, we say in a private matter or in a corruption matter, there is no conviction, the accused is acquitted. Still, the DG can move the High Court for asset forfeiture. And what is the burden of proof? Balance of probability, right? So take for example, a person is charged for corruption or bribery. That case fails. But still there are assets which he cannot account for. The Director General of the Bribery Commission can go to the High Court to forfeit that asset. Although it's not a conviction, but on a balance of probability. So, whereas the criminal conviction is on beyond reasonable doubt, if there is an unexplained asset, we know that now there is a separate law also governing that, but section 115 of the anti-corruption law provides for court on a balance of probability to order the forfeiture of an asset. So, these are all untested areas. How the inquiry is going to take place, what is the procedure to be adopted, all that, yeah, we are in untested orders. But this provision is there, right? For non-conviction based asset forfeiture, right? So it empowers authorities to target the proceeds of corruption, even if the offender cannot be criminally convicted. So we say there is some abandoned property somewhere, no one is claiming, right? We say there is some property somewhere. The suspect says it's not, accused says it's not mine. Everyone else also says it's not ours. Now, under this, of course, if you notice anyone interested to claim the property, then on the balance of probability, the court will decide on the balance of probability on the forfeiture, right? So, failure to report corruption, non-reporting by public officials on corruption is also an offense. So, there is a proactive duty to disclose wrongdoing, especially making a false statement to the commission. When the commission requests for information, refusing to disclose information, all those are offenses. Now, some of you who are in the private sector, those who are in the private sector working in the legal field, your companies might be called, information might be called by the commission. Then you might have a problem. Should I disclose this information or not? Then you have to realize that you are under a statutory duty to disclose the information which is required by the Bribery Commission. So there is also procedures for the commission to employ. Earlier we were used to the Bribery Commission having only police officers as investigators. But there is procedure now for the Bribery Commission to recruit other people from other disciplines, accountants, engineers, so on and so forth, for its investigative team, right? So again, this is in line with the practices of many other anti-corruption commissions throughout the world. In practice, whether how long it will take and who will be willing to join, all those problems may be there, but there is provision. Then there is provision in the law for interagency memorandums of understanding. Formal partnerships with the FIU, Financial Investigation Unit, the Police, Inland Revenue Department, Customs are provided for. And in the law, there is provided for streamlined information sharing and joint action. I must say this. Recently, I came across, I was doing a case for the Excise Department, and the court asked for some information from the Excise Department. And we were told the Excise Department, everything, and nothing on computer. Everything is paper-based, right? So, to find out what are the liquor licenses issued by the Excise Department, you have to go through every paper file, right? Through every paper file, which makes it all this in the law about electronic being interconnected and so on. will be worthless if we don't get everything automated and digitized. That would include, of course, our own area, the codes. So as long as everything is paper-based, even within codes, I think fighting corruption would be very difficult. And many of us know, I say this, I know that, as I said, that there are private professionals here, I say this, you find out how difficult it is to enforce executed court fraud. Writ, a district court writ, we all know, all of us know how difficult it is to execute a writ. And how it is virtually impossible to execute a writ, right? So, we can have all these nice laws on paper, but unless we can also enforce it within our system, anti-corruption is not done. So there's also provision for international cooperation that facilitates cross-border investigations. Then so this tries to meet Sri Lanka's international obligations. Asset recovery provisions, as I said earlier. So part of this is to encourage ethical culture and urges public and private sectors to adopt anti-corruption codes. Now I come to another important area, protecting the rights of suspects. Right? So this is, they're not much in the act about protecting the rights of the suspect. But I want to share this. I think it's important while we concentrate on anti-corruption issues as a defense counsel and also as someone who's concerned with human rights. I feel that this is also an aspect to be looked at. There is some provision about in the act about false evidence, but it is important that the rights of suspects are also addressed. Here I wish to highlight this as to the whole arrest of suspects and the public display which is being carried out when arresting suspects. I pose this question: is it really necessary? Is it really necessary to have this public display of marching suspects to court, the media arrests? I think it is my view that in the long term, it is going to be counterproductive. Right? If you look at many years ago, we had a very active bribery department in the 1970s under Mr. Felix Bandaranaike when he was Minister of Justice. If some of you saw the film Sagaraya Method, right? There was a person who was ordering, he was the bribery commissioner. Actually, the bribery commissioner at that time was bribery commissioner under Mr. Felix Bandaranaike's time. In the Sagaraya Method film, he acted as himself. He took part, he was acting in the film. Right? So he's a lawyer, he took part in that role. Now we must be careful that when we are preparing, as a country, we are strengthening the anti-corruption regime. We must ensure that the rights of suspects are protected. Because if arresting a person, the Supreme Court has explicitly said that remanding must be the exception. Recently, Justice Kodagoda, the judgment of Justice Kodagoda in a different context, SCFR 346 of 2018, we were in early July, where the court says that repeatedly the Supreme Court has said that judges must not unnecessarily remand suspects. But we know it continues to happen. So I want to highlight is that it is imperative that prosecutors, whether in the agency department or in the private commission, and investigators are mindful that people must not be arrested and harassed unnecessarily. I say this because I am also fear for police officers who have been sometimes arrested and produced as suspects. Many years ago, I appeared for a gentleman, I won't mention his name. He was named as a suspect in the Lalitha assassination case, because his name came up in the commission as a suspect. Actually, there was very little evidence against him, right? But he was arrested and produced. We managed to convince the chief magistrate at that time, Mr. M.A. Silva, was the chief magistrate, that there was no evidence. The chief magistrate just released him on a bond, right? Then this particular officer told me, he said, sir, I want to hear it. This is a matter of the මට තේරෙනවා ඒ ටෙන්ෂන් එක ඒ අවස්ථාවේ ටෙන්ෂන් that was what Glavay you got remanded and you had to go to the high court to get here, right? So I think police and investigating officers, prosecutors must be sensitive that I'm not saying that don't remand people when there is necessary to remand. If there is a necessity, please go ahead. But keep in mind that not everyone you arrest are ultimately going to be named as suspects. I want to share this. There was a public officer during the 2015-2018 time. He was the representative of the treasurer in a particular board, in the tourism development board. The treasurer representative. There was a case in the tourist, there was a case filed by the agency by the CIA, where it was alleged that there had been a fraud in the board. So he was a member of the board, and they said that he had signed the board paper, right? And he was produced under the Public Property Act. The magistrate said she wants to look at the papers. She said, I have studied the papers, I can't do a decision. So she demanded him for 1 day. But she gave the order the next day, she gave him bail. Right? A very senior SLS officer. He was ultimately, later on Director General of Customs also. That 1 day in remand devastated him. It affected his family, it affected him. Ultimately, the Attorney General's Department decided not to charge, not to proceed against him. Why did he have to spend even a day remand? What was the decision? So, we have enough case law to say remand should not be a punishment. So, I emphasize this because while tackling corruption, you must also be conscious about the rights of others. Justice Mark Forever, Big Tiger versus Sabat Silva, has talked about investigations being fair. Because a fair investigation helps to convict the people who are guilty, but it also, a fair investigation will protect the rights of the suspects. Right? So, the need for a fair investigation is imperative. And as we go along with this anti-corruption regime, I think we must, as a bar, fight for a fair investigation process. Right? And then the next one, trial by media. Right? Very often now, what we have is trial by media. The media decides who is guilty, who is not guilty. Social media, Facebook, people decide, and people also decide who must appear and not appear for suspects. Right? So, I must say, I have taken a conscious decision that I don't care what social media says when I appear for suspects. Right? I don't care. I have taken that policy decision that I don't care whether people score me or not, or me. Right? But I want to say this because we must frown on this trial by media because it's very dangerous. It does not help the process in the long term. The same populist media who cheer you, who cheer the investigators, 2 years' time, when tables turn, they will cheer the other side also. Right? And so that we must be careful. And I think there must be, people must not be allowed to comment on ongoing cases so as to influence the decision-making process. And that is where I would think the Bar Association should think of a way to prevent that sort of, because that is not a fair trial. So this is, I want to highlight this also while discussing the provisions of the new Bribery Act. The new Bribery Act has over 100 sections, but so in summary, the new Act strengthens the institution. The institution is now independent and stronger than it ever has been, right? And that independence, that power can be used for the benefit of this country. But you must also remember that when institutions have too much power, that can also have an adverse outcome. It would depend on those who are managing those institutions, whether that power is used properly. Right? Justice Mahaprabhu refers to he said it is good to have giants, he quotes from Shakespeare, that it is good to have giant's strength, right? But at the same time, you must be careful about when you have giant's strength, right? Because you can overreach. So it's a strong, independent institution. Why investigative powers? New areas are covered up. I identify the private sector bribery as a vast new area, and we know that there is corruption in the private sector. We know that the private sector itself there is bribery and corruption, and so that is addressed. Sports, which have been concerned to many of us about how there is so much of corruption in sports, there is an opening in the law. Conflict of interest is also a new area. Freezing or seizure, forfeiture of assets, non-conviction based forfeiture of assets, asset declarations in a new format, electronically, and covering a wider area. The Bribery Act itself, the definition of public officer has been expanded. Actually, I must tell you, during the bill stage, they left one important office out of it. The office of the president was left out. The bribery, the anti-corruption bill had left out the office of the president from the definition of public office. The Bar Association who pointed out, which I challenged the bill, I was counsel. Then we pointed out that the president must be included, so the president is also now included in the definition. Right? So these are some of the saying features of the bill, but I would advise you to read this new law because it is important both from a professional point of view. And it might also be that as professionals, we also need to be careful on the professional work we do, that it does not get caught up in some of those sections, right? Remember that we also should not cross that line, right? We must know what we professionally have to do, but what is not our task, we must avoid. So it is not our task to get involved in bribery, right? If you offer your services as a profession, but you must be careful that you do not engage in corrupt practices, or you should not get involved in bribery. I say this again because sometimes it can that crossing that line, some people might unknowingly cross the line. You have to be careful that you do not cross the line because then you too can get caught up in some of these sections, right? So that it is important to keep that in mind. So these are some of the highlights of the anti-corruption regime. I would like to open for a few minutes. I'm conscious that we have stopped before, but for a few minutes we can open up for questions. Any questions? You don't have questions? We can all wind up, but any questions on the new law? Maybe the certifications, some of you would right. So, Himani brings up this question, gifts. I think when you are, the definition is quite wide. So, within the meaning of gratification, if you are a public officer, most certainly gifts will come within this. In some other countries, there are regulations in place. A value of a token gift might not come within this. But again, as a public officer, I think gifts you are going to take. except hampers, bottles, so on, will certainly come within the definition of gratification.
So you think that this will evolve in the future and people will file cases and prosecution will go on and will we really get into this law, or it's just a nice piece of act, or
So that remains to be seen.
so that is our part that we have to see actually.
So that remains to be seen, because as we all know, we can have the best of laws, but Sri Lanka's problem over the years has been the implementation of the law. We have had good laws, but when it came to implementation, we have stumbled. So that is, I think, the challenge which the Commission and the DG has to ensure that you build a long term, in the long term, you build an institution which is credible and which is safe. So that is where I think what is important for a balanced approach on the part of the prosecutors also. Right? If you do not adopt a balanced approach, given a few years, you are going to stumble. But if you have a balanced approach, a fair approach, I think in the eyes of the public, remember that all these are institutions, all our institutions, including the judiciary, we rely on public confidence. If the public don't have confidence in our institution, we fail. Right? So it applies to our legal profession also. It applies to our profession also. Eventually, if there is no public confidence, we will all fail. So the answer to your question is, we must hope that this is a strong law, a good law, and that's what the Supreme Court also has said. But it's a powerful law, so how the institution evolves, we have to wait and see. Right. So there is provision for an integrity officer to be appointed. There is provision for each institution, recommendations to be made in institution, so on. But again, you can appoint all the officers you want, but then it also depends on the culture which is there in the institutions and how we are going to evolve. So, any other questions? Does anyone want to make any observations? I know that there are those who are lawyers who are involved in the commission. You want to
Yes.
happy to let you make some observation, or if you don't quite understand. So this is just one. This is an overview of what the law is. But please do look at the law, because it is going to play an important part in our court system in the future. And on one hand, if you are in criminal defense, also there are so many areas to look at. But one advice is, as I told you earlier, see wherever possible, you must also see that you can resolve the matter for your client. And that part of it is not every case to go challenging everything, but to see where certain cases, if it is more advisable for your client, where you clearly see that the client is wrong. There is no way out. Compromises are possible under the law. And that deferred prosecution controls set out what can be done. All right. So thank you for listening to me.
Thank you, Mr. Sari Pires, President's Counsel, for that insightful, thought-provoking, and engaging lecture on the new Anti-Corruption Act. To appreciate Mr. Sari Pires' contribution to make this session a success, I cordially invite Mr. Sari Jayawardena, Assistant Secretary of Bar Association of Sri Lanka, to present a token of appreciation for Mr. Sari Pires for his contribution. With that, we have come to the end of today's morning session of the Legal Symposium. I would like to remind that there is a session open for resident participants, which is to be held at 7 p.m. today. with the participation of the President of BASL Sri Lanka, Mr. Rajiv Amarasuriya, which will be followed by a fellowship and an opportunity to network among the members. We have a band who will be performing for us, so we hope you all get an opportunity to enjoy yourself. So I would like to, in concluding today's morning session, I would like to thank our resource persons, Mr. Ikram Mohammed, President's Counsel, Mrs. Arif, Previous President's Counsel, and Mrs. Shirani Guruvardhan, Senior Instructing Attorney, for their contribution they have provided, and for you all for your participation. Thank you.